Yeah, Warren Sprouse, this is the Bible Forum. We're here every Sunday night from 8 to 10 p.m. We do this for you, looking at life through a biblical lens. We're talking about the events that occurred this week in the Ninth District Court. You had to be living under a rock not to hear about this. Our new president issued an executive order banning visitors to the United States from 7 countries the Obama administration identified with state-sponsored terrorism. The ban was for 90 days. The hope apparently was to get organized so that we could then reinstate this and do it in a more decent and orderly fashion. Liberals jumped up and screamed bloody murder. It wasn't fair. It created hardships. It did everything. It didn't do it the right way, and it's too much, and they went on and on and on. Well, 2 states, Washington and Minnesota, 2 states that were not impacted by this order at all, appealed the executive order to the Ninth District Court of Appeals. Now, the Ninth District Court is notoriously liberal. Their decisions have routinely been overturned by the U.S. Supreme Court 86% of the time in the last 10 years. The Ninth Court appointed a 3-judge panel to hear arguments. We listened to much of it. If you tuned in to Fox News, perhaps other outlets as well, while it was going on. It was on the West Coast, so they were doing this at 3 o'clock in the afternoon, but it was 6 o'clock here, right at news time. And they let us listen in. It was a phone thing that they were doing with these 3 judges. In the end, the panel, and hence the court, found in favor of the plaintiffs, and the executive order was overturned. Was that a right thing, a wrong thing? Well, you have your opinion. But listen to Judge Andrew Napolitano, former New Jersey State Superior Court judge, weighing in with the legalese that is behind all of this. He said, and I'm quoting, a 1952 federal statute permits the president to suspend the immigration status of any person or group whose entry into the United States might impair public health or safety or national security. Trump exercised that authority in accordance with the 1952 law when he signed his January 27 order banning all immigration from the 7 named countries. He went on to say, when the president exercises powers granted to him by the Constitution or federal statutes, or when Congress passes bills, one cannot simply sue the government in federal court because one does not like something that has been done. That is so because the Constitution has preconditions for a lawsuit in federal court. One of those preconditions is what lawyers and judges call standing. Standing means that the plaintiff has alleged and can most likely show that the defendant has caused the plaintiff an injury in fact, distinct from all others not in the case. Hence, he writes, it is curious that the plaintiffs in the Seattle case were not people whose entry had been barred by Trump's order, but rather the governments of 2 states, each claiming to sue in behalf of people and entities resident or about to be resident in them. The court should have dismissed the case as soon as it was filed because of long-standing Supreme Court policy that bars federal litigation alleging harm to another and permits it only for the actual injury or immediate likelihood of injury to the litigant. Nevertheless, the Seattle federal judge heard oral arguments on the 2 states' emergency application for a temporary restraining order against the president. And during that oral argument, the judge asked a lawyer for the Department of Justice how many arrests of foreign nationals from the 7 countries singled out by the president for immigration suspension there have been in the United States since 9/11. When the Department of Justice lawyer said he did not know, the judge answered his own question by saying none. Napolitano says the judge was wrong. There have been dozens of people arrested and convicted in the United States for terrorism-related crimes since 9/11 who were born in these 7 countries. Yet, even if the judge had been correct, his question is irrelevant, and hence the answer is meaningless, because it does not matter to a court what evidence the president relied on in this type of order. This is the kind of judicial second-guessing, Napolitano says, substituting the judicial mind for the presidential mind, that is impermissible in our system. It is impermissible because the Constitution assigns to the president alone nearly all decision-making authority on foreign policy, and because Congress has assigned to the president the power of immigration suspension as a tool with which to implement foreign policy. These rules and policies, the requirement of standing before suing, and the primacy of the president in making foreign policy stem directly from the Constitution. Were they not in place, then anyone could sue the government for anything and induce a federal judge to second-guess the president. That would convert the courts into a super legislature, albeit an unelected, unaccountable, opaque one. Judge Napolitano is quick to say that he's not suggesting for a minute that the courts have no place here. Rather, that they have a vital place, which is to say what the Constitution means, to say what the statutes mean, to determine whether the government has exercised its power constitutionally and legally. It is not the job of judges to decide whether the government has been smart or prudent. One of the arguments made by the state of Washington to explain why it had standing was laughable. Washington argued that corporations located in Washington would suffer the irreparable loss of available high-tech qualified foreign employees if the ban were upheld. Napolitano says even if this were likely, and even if it were provable, it would not establish injury in fact to the government of Washington. When pressed to reveal what entity Washington was trying to protect, it enumerated a few familiar names. Among them was Microsoft. Microsoft? The government of the state of Washington is suing to protect Microsoft? Microsoft could buy the state of Washington if Starbucks were willing to sell it, the judge said. The rule of law needs to be upheld. Carefully paying attention to constitutional procedure protects personal freedom. In similar environments, the late Justice Antonin Scalia often remarked that much of what the government does is stupid, but constitutional, and that the court's only concern is with the latter. The Department of Justice is now challenging the Seattle restraining order in the Ninth Circuit Court of Appeals, and this case may make its way to the Supreme Court. Will the federal judges be faithful to the rule of law? We're going to have to wait to see. What we're seeing here is what liberals do when their pet projects are threatened. What we're seeing is how committed they are to their ideals rather than the rule of law, which they swore to uphold. The story is old. Pack the court with your people and get your philosophy established as law. That a sitting U.S. Supreme Court judge, Chief Justice no less, could change the wording in a case in order to get it through the high court with no real concern for the majority is nothing less than astounding. And that's exactly what happened when Obamacare became law. It came before the high court, and Chief Justice John Roberts changed the term from fee to tax. And voila, a new law was born. Not the one they brought to the court, the one the court adjusted for reality. Those of us committed to established law and to the ordinary definitions of English words voted no, but we were in the minority. Isn't that amazing? All of this is part of something that's now being called the shift. We have no room to talk about it here, but check the YouTube, the video from February 12th, 2017. We talk about it at length. The president's ban on immigration is apparently lawful. It wasn't fair because it stopped all immigration without warning and seriously inconvenienced some folks. No one to date, however, has been able to find someone who actually was damaged, but that's a technicality. They were delayed, they were denied, they were inconvenienced, and that's enough. What's really at stake? The money these liberal states get from the feds for every immigrant, documented or not, that comes through their state. It's just over $2,000 apiece. Each immigrant then represents a citizen of that state. Even though they aren't citizens, they live there. They contribute to the population. U.S. representatives are established based on, population. The more people in the state, the more representatives. In a liberal Democrat state, that means more Democrats in Congress. It's a money power game. Did I mention the ban was only for 90 days? Time to get things under control. But control is the last thing a liberal can tolerate. That and the Constitution of the United States. Do you realize that our court system, as it was established in the early 1800s under our Constitution, is to stay out of issues that have to do with security? That's all to the president. He gets the security briefings. The judges don't. And they don't want the judges getting those security briefings. It's too many people in the system. And so the president gets to sign these orders because he knows things they don't know. But when you have a liberal mindset, you know everything.